This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Well, good morning, Treasure Coast. This is Stuart Address, and this is Ask a Lawyer. It seems that another week has passed. Not an uneventful week in my office or in the country. But I will tell you something that occurred in my office yesterday when I had a prospective new client in for a consultation and who happened to have heard of us on the radio show, which was wonderful. But he said he was very confused when trying to figure out who to call. And that's because he kept hearing Stuart Address and thought that must have been a mistake. And I said, no, that's my real name. It's Stuart Address, just like address, ADDRESS. I said, maybe I'll have to start giving some sort of disclaimer like that now every show. But if people aren't here at the beginning, they won't know that. And let me here just change headphones because I can't hear anything. We don't want dead air. All right, I'm back, and now I can hear perfectly. Whoa! And there goes the live Facebook.
I'm sorry, Facebook people went for a ride.
Yes, it was a roller coaster. A roller coaster caused by my producer.
Whoopsie.
I think we might need to sue her. What would the cause of action be? Well, the iPad was close enough to me. It could be assault. I don't know. But anyway, folks, there really is an attorney in Stuart named Stuart Address.
That would be you.
That's me. And if you have a problem with the last name, as somebody recently told me, look in Stuart for attorneys named Stuart. You're not going to find anybody else. All right, so let's move on. We had a gentleman come into the office yesterday who, as I indicated, he and his wife had heard us on the radio show, which is wonderful. It's nice when that happens. And I won't get into too much detail, but it was an issue that involved a homeowner association dispute. And a couple things happened which I really thought would merit discussing at the opening of the show because it happens a lot. It could happen to anybody. It can happen to any attorney. And part of it is a matter of the difficulties of, in roughly an hour consult, interpreting legal documents that are long. And part of it is when other attorneys quote from statutes and documents and don't do so accurately. So what really happened was I was asked to give an opinion on whether an assessment of the homeowners association was lawful. And I was given an entire set of facts, and all the facts sounded quite reasonable. And unfortunately, things that often sound reasonable don't equate to being, what the law requires. And so we're looking at the communications that this gentleman had with the HOA and with the attorney for the HOA. Now, the attorney for the HOA happens to be a very prestigious law firm that tends to know what they're doing when it comes to homeowner association law. Okay. So I'm looking at his communications to them and their communications to him, particularly 2 letters written to him by the attorney for the HOA. And I ask him a few more questions, and the hour is roughly up. And I have to tell him, unfortunately, I don't think you have a cause of action. I don't think what the HOA did is contrary to either statute or the Declaration of Covenants. And while what you're telling me makes a lot of sense, if it's not a violation of statute or the Declaration of Covenants or the bylaws or the rules and regulations, then there's really no claim. And of course, he was not overly thrilled.
Mm-hmm.
But then something jumped out at me. And so we spent another 45 minutes, which is not typical, honestly, in a consult. But, one of the lessons is sometimes it takes time to get to the right answer. Because I was fairly confident in the opinion I was giving him. And if I had sent the gentleman off on his merry way after give or take an hour, I would have given him the wrong advice. And that's a risk that any lawyer has. It's a risk that any potential client getting a consultation has, that you get the wrong information. And it's one of the reasons why I always say, if I don't think a potential client has a claim, I always tell them to at least talk to one other attorney, because they may see something I didn't see. They may look at it differently.
Mm-hmm.
My interpretation, especially in an hour consult, is certainly not gospel. And what happened in what turned out to be another 45 minutes is he said one sentence to me which caused a light bulb to go off. And I started going back through one of the attorney's letters and looking at a section that he had quoted from the Declaration of Covenants. And what he said, this particular section of the Declaration said, is not what the section said. I was looking for his quote, and now I'm looking at the Declaration, and part of the quote is there. But the rest of it, which is key, is not what it says.
Is it somewhere else? Did he combine things, maybe?
I think he
But
tried.
you can't say it's a quote.
Right. I think he tried, but I still think it was inaccurate.
Okay.
And I don't want to get into too many of the details because it could prejudice the prospective client whether he retains me or not eventually. But suffice it to say, what happened was, when I saw the quote was not truly a quote, I started pouring through the Declaration of Covenants in a lot more detail. Every section that he referenced, I was looking at much more carefully, word by word. Went to the statute he referenced, which does say what the attorney said it said, with one exception. It starts off, unless stated contrary in the Declaration of Covenants. Well, now as I was interpreting the Declaration of Covenants, it did state contrary. So the statute could no longer be used to support the theory that the HOA was advancing as to why it didn't have to do what this prospective client, this homeowner, was asking it to do and saying he had every right to have done. So in the end, we sort of ended it with, all right, I have changed my mind. I think that we can argue that you've been treated improperly under the statute and under the Declaration. The question is now how to handle it. And, of course, I quoted him a fee for me writing a response to the attorney, trying to logically explain why what the attorney had set forth as his rationale was not correct. Now, sometimes that falls on deaf ears, because we're all advocates. And sometimes...
Yeah, and he answered your prospective client with his letter, and you now have responded to that.
Well, no, I haven't.
Okay, but that would be the outcome
that would be,
if he hires you.
If the client hires me to do a demand letter, that is exactly what I would do. I would explain point by point why he's wrong. Now, a lot of attorneys don't want to hear that, so, you get a blind eye, a deaf eye. I looked up his status in his law firm, and I see that he's not a partner. So presumably this is a big enough client that if he has any doubt, he's going to need to take, let's say, a letter that I write to the partner to look at and to now interpret who's right and who's wrong. And it's always our hope that when you get higher up in the food chain, partner's going to look at this, not wanting to just blanketly say my client is right, but wanting to be right. And if the client is wrong in this particular instance, a good attorney will tell the client, this time around, you don't have a good case. And let's work this out, which would be the goal of the letter. So I told him it could work out that way. It might not. Well, okay, what happens if it doesn't? Under the statute, you're allowed to demand mediation. Here's how much extra that would cost. If you don't come to an agreement and end the matter, either side could file an action in circuit court. Under the statute, once that happens, either side could demand non-binding arbitration, which to me is crazy. Arbitration is supposed to be a final decision, but there is such a thing as non-binding arbitration. And the reason for that is, as opposed to a mediator who doesn't give you an opinion but just tries to help you come to an agreement, even in non-binding arbitration, the arbitrator will give an opinion. He will find for one side or the other and write an opinion that gives the rationale. At that point, either side can say, I don't like the decision, and ask for a regular trial before circuit court. But there's a penalty if they do so and they lose. And the penalty is all the costs and all the attorney's fees from, let's say, from the time I wrote my initial letter, through mediation, through the arbitration, and then through the trial, which could be very substantial by that point. So one would like to believe that typically if you get to non-binding arbitration under a HOA statute, whatever the outcome, unless it's really, really weird, both sides will choose to follow because they don't want to accept that potential risk of being hit with all those fees if they don't prevail. So what's the moral of the story, I guess? There are a number of morals, I think, for prospective clients, for attorneys, for myself included. For clients, an attorney can try to be doing the best job possible, looking at the documents as closely as possible, trying to hear and understand everything you're saying, but in a limited time may not have the opportunity to go beyond the initial reaction and seeing if it's supported by the law and the documents and give you that opinion. Most of the time, if you have a good attorney, an experienced attorney, most of the time I think that's probably correct. I think the vast majority of the time that's correct, or I wouldn't be doing, hour-long consultations, and most attorneys wouldn't be doing it that way. But there are situations, especially if it's more complex, or there are contractual documents or statutes that you really have to look word for word, sometimes clause by clause.
And it was written by lawyers.
Right.
We all know what that means.
Comma by comma sometimes.
Hard to read.
Right.
Very hard to read.
You have to look at the except otherwise and, all that kind of stuff. So for the prospective client's point of view, be sure that when you leave any consultation, that you have the questions you want answered, that you at least understand the lawyer's reasoning and why they're giving that answer. And if you still think they're wrong, go see at least one more attorney. It is worth, whether it's a free consult or a paid consult, which is a few $100, it is worth seeing one more attorney before you give up on a matter that could be very expensive, okay, in my opinion.
And we have to assume that, like in a case like this, it's a homeowners association. Something's happening where he lives that's just not cutting it.
Correct.
So having that resolved, I mean, it's a matter of your day-to-day life.
Right, and it's going to continue into the future if you just accept how they are going to handle it, and if it costs you money every year or every month, well, it's going to be forever until you leave.
Yeah, I was going to say, but that's where you live.
Right.
Yeah.
So the moral for, I think, the attorney, including me, is that before you give that final opinion and send this prospective client on his way or her way, especially if they haven't retained you and you may never hear or see from them again, you really have to take a quick second look. You gotta look at documents, key provisions, statutory provisions that may be significant, and you've got to make sure that in interpreting language, you haven't missed something important. And what did I do that changed my mind? I mean, yes, the client said something which sent off a red flag in my mind, but the client really didn't give me a new fact. It's just the same fact stated a different way. And it made me think I need to compare the quote of the lawyer versus what's in the declaration. And I need to look at the declaration compared to the statute. And it was only when I found that it didn't say what the lawyer said it said, and it was only when I found that the first opening of the statute was, unless otherwise provided in the declaration, this is the law. Well, if we just looked at this is the law, the client had no claim.
Right.
But
what did they mean by that other part of the sentence?
Right. And now I look at the declaration for a second time and I say, doesn't say what he said. And I think based upon what it does say, you have a legitimate claim for these reasons. Different opinion.
Well, he got an opinion and a second opinion all in one counsel.
That's right. And he will think about it over the weekend, which is not uncommon. And, we'll see whether or not he wants to proceed one way or the other. But I think for the client, even though there's a rough time limit with most attorneys for a consultation, I mean, look, ours is give or take an hour. We take longer. Sometimes it's shorter. We try to give a prospective client the time they need, but not, not the whole day.
Right.
Okay. I try to make sure that, I'm comfortable when I'm sending them off on their way and saying, well, either I think you have a claim, would you like to hire me? Or, no, I don't think you have a claim, and, I'm sorry.
Good luck with that, yeah.
Good luck.
Yeah.
The client should make sure that at least they feel their questions have been answered in a way that is logical. Maybe it's wrong, but at least in a way that is logical. And then go check it.
Now, this was a HOA dispute. Tell us a little bit about all of the other things that you do, because we haven't done that in a few shows.
In a few shows, okay. My goodness gracious me. Let's start with a little bit about a few areas that I emphasize. And I can't and I won't say specialized because it violates Florida bar rules.
Right.
Because unless you are actually certified in certain areas, you cannot hold yourself out as a specialist. I emphasize employment law, all aspects of employment law. That could be wage and hour, family and medical leave, termination, whistleblower act for complaining about something and then all of a sudden you find you're fired, retaliation claim for filing a workers' comp claim, and next thing you know, you're fired.
Yeah.
So all aspects of employment. Also connected to employment, we do a lot of what's called Title VII discrimination claims. So it's what is protected under Title VII. It is you are protected against gender discrimination, age discrimination, discrimination based upon national origin, religion, I think I said age, pregnancy, sexual harassment, big issue today. There are a few others. There is a big question today as to whether Title VII protects you from discrimination on account of being gay or transgender. Now, gay is a slightly more settled question because historically the courts have interpreted that as a gender-based discrimination. Not all courts, but generally, and one day it'll probably get to the Supreme Court, which is why who you put on the Supreme Court is so important.
I'm just sitting here thinking that sexual preference should not be anyone's business.
Well, you're right. It
should never get to that.
Well, but unless the law protects you against it, they can do what they want. All right. The transgender issue is very, very new, of course. And the Department of Labor, which is the agency assigned to interpret the Title VII and promulgate regulations, has issued a bulletin that it views transgender-based discrimination as covered under Title VII, again based upon gender. The Trump administration is up in arms about that, and is challenging it. So what the end outcome will be with regard to whether or not you are protected against discrimination based upon being transgender, I don't know. Right now, I'd have to look, and I don't know offhand, honestly, within the 11th Circuit, which is our federal circuit, whether or not any federal court within our circuit has accepted transgender as being a protected classification. Because if it hasn't, then there's no way to bring a claim. I mean, you can bring a claim of first impression, but then it's going to go up on appeal, and you better be prepared as a lawyer and as a client for the long haul. If it has, you can bring the claim and win, and the other side might bring it up on appeal and try to argue that it shouldn't be.
What kind of
covered.
rights are they not getting? I mean,
all the rights that anybody
because
else.
You're differentiating between gay and transgender
Right.
now, so why?
Because gay has been around much longer, and there have been litigation over it.
Okay.
Transgender has become a social issue within the last couple of years, and there isn't as much federal court decision on it, especially decisions of different circuit courts of appeal, because once there's a conflict, then eventually it winds its way up to the Supreme Court. And I would think that if there was a conflict, and inevitably I'm sure there will be, that inevitably that issue will present itself to the Supreme Court, because it is the Supreme Court's responsibility to resolve conflicts in this different interpretations of law by the different circuits. The only way to resolve that and determine nationally what is the law is for the Supreme Court to then speak. So one day it'll get there. But when generally before we take a question or two, when you ask, what are the rights that are protected? It's everything associated with your employment. It's your right to have your job.
Okay.
It's your right not to be punished in duties and responsibilities.
What happens if you don't get a job because you're not eye candy?
Eye candy?
Do you have because you're not?
Yeah.
Do you have a?
Yes.
Do you have a suit?
You do. It's tough. You do.
I mean, what if they don't like you because you have red hair?
That's okay. That's okay.
That's not discrimination?
No, it is not. And if you have big ears and they don't like big ears, tough luck. If they think you have a big nose, tough luck.
But if you're gay?
You're generally, I believe, you're protected.
Well, that doesn't seem fair, does it?
Well, fair and the law are often two different things.
But what would have to happen is you'd have to litigate every single case then, right?
Well, you would, but no lawyer is going to want to take on a contingency fee every single case unless there's some precedent.
Just because you have red hair, I'm not going to take this case.
Well, no.
It's not going to win.
If there's no basis in law to say that's a protected classification, then no.
Okay.
I mean, I've said to many people, unfortunately, it doesn't matter. They don't like long hair
or big ears. So all the folks with big ears need to get together and litigate.
Before I take these calls, I will give you one contrary example. Gentleman called me one day with dreadlocks and said that they said that he had to cut them or that he was going to be terminated.
Yeah, because at the fast food place they don't want.
Right, exactly.
Yeah,
and he said, I offered to put them up in a bun.
Okay.
They said, that's not good enough. Turns out, female employees with dreadlocks are okay. This male was not. And he had indicated the dreadlocks were predicated upon his religion. And from everything I discussed, it seemed like an honest belief.
Sure.
So there's another.
He's a Rasta man, right?
Yeah. So there's a religious protection, and then there's a gender-based issue. We wrote a letter to the company, and, they let him put his hair up in a bun.
Okay.
So, all right, which one should I? Bulldog?
No. Go
two?
Dorothy, yeah.
All right, let's talk to Dorothy on line 2. Hello, Dorothy.
Oh, good morning, sir. Thank you for taking my call.
Oh, well, not a problem.
Question.
Sure.
I have been searching for employment, and I have been on several websites, and I get these calls that ask me what year I graduated from high school. So they don't ask you what your birthday is, but they figure out from the time you say I graduated such and such a year. Is that considered the same thing as age discrimination?
Probably not, and here's why. And I understand exactly the point you're making. that anybody can do a mathematical calculation and get at that same issue as to date of birth. The reason I don't think so is because when you graduate high school, when you graduate college, these are standard parts of a resume. And so asking you, did you graduate high school? When?
Well, yeah, that would be yes or no, but then when changes
Well, they're
it,
allowed to
right?
verify it.
Okay.
They're allowed to seek to verify, your essential credentials. So for that reason, I don't think that alone would give rise to an age discrimination-based claim.
Oh, well, is that the way they're getting around that?
I honestly don't know. It seems logical that some employers might do that. I've actually never had anybody discuss it with me.
Is there a place where you have to put your birth date? Because that
Gen-
would be
Well,
really
No,
when
clear.
generally no.
Okay. Okay.
When you actually, do the application, this is the screening process, and I started lying. I'm telling them I graduated 20
All right,
years after.
let me tell you.
graduated.
Here's the danger with that. I'll be very frank with you. You could be employed now for 20 years, and they find out you lied. You're fired.
Oh no, I understand that part, but what I'm trying to say is you can't even get in the interview because they don't even push your resume forward.
But if you do get the interview, what are you going to do? The first thing in your interview for a job, you're going to tell the interviewer, well, I have to tell you, I didn't tell the truth about my age on the application.
No, you were filling it in on a computer.
No,
you hit the wrong
when
key.
your application.
Right.
This is the screening call.
No, I know.
What year did you graduate high school?
I understand.
Well, I put down my college
It's a
graduation.
typo.
I understand your concern, but from the employer's perspective, the moment they find out that's not true, you're not going to either get the job, or if you got the job, I've seen many people fired because they find out something wrong.
Well, on my resume, it clearly states when I went to school and
Okay.
when I graduated. But as I said, you can't even get to the
I
interview
understand.
part because of the fact that you graduated,
Right.
in the year of the flood. Well, so be it.
And I hear you, and except for the argument that perhaps it was a typo on a computer, which may or may not be believed.
That'd be my story.
It's I understand why you're doing it, and I can appreciate it, but it is dangerous.
Well, the point I'm making is I think it's unfair for them to, in a screening process, to find out, instead of trying to find out would you qualify, they want to know what year you graduated
Well,
from high school.
when they ask for all your prior employment, in a way you can argue that they can calculate back from that if you have a long history of employment. I mean,
Right.
those kinds of things have to be
even if
have
you
to
say
be permissible.
you have years and years of experience,
That's not going to get you anywhere. Come on.
it tells you you're old.
Yeah, no, you
Anyway, I just
I
find
hear
it
you.
interesting that they, instead of asking you. So, in essence, they are discriminating.
Well,
based
maybe
on
you don't know if that's their intent, or if they're just screening to verify you have a high school education, a college education, whatever it is. I do concede that some employers may be using it as a subterfuge, and I guess unless it's litigated one day by somebody, there will have to be a decision whether that is or is not a subterfuge for age discrimination.
In my opinion, it is.
I do understand.
Well, now a lot of places are using outside sources for, like Indeed or these
Right,
places
there are
that
so
help
many
you.
there are so many ways to figure this out these days.
So it's not on them. Actually,
No.
the screening process isn't even on the employer.
Thank you very much, Dorothy.
Thank you. Bye-bye.
Bye-bye. All right, I think we have our dear friend Bulldog on line 1.
Hello, Stuart M.
Hello, Bulldog. Where are my bagels?
Sir, one comment, a quick comment or a parallel to your dreadlocks.
Hey, I don't have dreadlocks. I have very little hair.
He
No,
wishes
I
he
was
had
just
dreadlocks.
saying how they had to.
I used to have an afro. Go ahead, Bulldog.
Okay, that'll look good on Dancing Queen night. Anyway, But yeah, my cousin applied at Publix. He had to shave off his goatee and everything.
Oh, really?
And I had to tell him the next day that Publix relaxed the rule
Yeah.
as of the 29th.
Yeah, that's
On the
new.
facial hair?
Yeah.
Yes, exactly. And
Bulldog,
so
did you
I
hear?
just thought that was a funny, sideline.
Did you hear why they did that? They said the people who would like to see people clean shaven are aging out.
Really?
So
Well,
Maybe the
that
executives
felt
are
like-
aging out.
That felt like me, you know.
well, my cousin
aging out.
also has tattoos and everything, so he's got to wear a certain shirt.
Yeah, yeah, yeah. A lot of those rules are legitimate. Facial hair and covering up tattoos and
stuff
things
like
like that.
I mean, you are working with food, even though it's not prepared food.
depending
but,
upon,
you know.
depending upon the type of employer.
Yeah.
A lot of those rules can pass constitutional
Okay.
muster.
Anyway, I wanted to go back to your first, the one that you're working on.
Okay.
And I've had many battles with the HOA. And I just hope that this guy got an exit plan either way that this works. If it's against him, he's got to be gone. And if it works for him, that's fine. He's got to be gone anyway because he will be under scrutiny like you won't believe.
Well, I do agree with you that if it goes against you, you probably do want to sell if you can without sacrificing a lot of value. If it goes in your favor, I also agree that they might be looking more carefully at you. But to tell you the truth, I would tell somebody who prevailed, don't go anywhere unless you want to go anywhere. And if anything funny happens, if anybody looks at you cockeyed, give me a call because I'll be looking for retaliation.
Oh, no, I think they'll do it in legalese, and there won't be thing one you can do about it.
You might be right because some things are so subtle they can get away with, but I have found, particularly with HOAs, they're not usually subtle enough because the members of the board are average day people, and they often do not know how to do things subtly and tip their hand.
Right, and they'll just report anything if you don't cut your grass, if you don't do this, if you don't do...
Right.
I mean, they'll
So then what you do is you look at selective enforcement. You look at, and I've had cases like this. All right, you got a citation for your grass being a half inch too high. Let me see for the last 5 years how many citations were given out by the HOA for grass being only a half inch too high. Let me see how they've handled those citations.
And then walk around your neighborhood with the ruler.
No. I mean, you get the records. And if all of a sudden you see, well, they've never issued any such citations to anybody unless grass was at least 2 inches over what is specified, then you know it's selective enforcement, and that is retaliation.
Excuse me, however, I'm already into you for lawyers' fees, and every time something like this comes up, it's more lawyer fees, and, I'm not questioning that you don't deserve them. What I'm saying, it is, if you win, that's one thing, but, it's still a crapshoot.
Right.
So do you want to just reduce the headache? And that's why I'm
You're right.
saying, even if you win, get out.
You're right, and this is what I told the prospective client yesterday when we were discussing what it would cost for a demand letter, what it would cost if we had to do a mediation, what it would cost if we had to go to non-binding arbitration, and at what point do you say uncle, okay? And what I said to him essentially was, there is, in this particular statute, of course, an attorney's fees provision. So it is possible that at whatever stage you prevail, you can get your attorney's fees paid back. But don't count on it. I mean, I always tell a client, even when there's an attorney's fees provision in a statute, do not assume that you're going to be getting your fees back. Because if there,
court costs.
if there's a settlement, if there's a settlement which occurs in more than 90% of all cases, guarantee they're not going to be paying your attorney's fees back. So yes, you're right. A client has to look at what is the likely expense of fighting, and that's where, at least what my sign out in front of my office says attorneys and counselors at law, and I take that seriously. It goes back to the old days from as I've often mentioned on this show, good old England. The attorney, I give you the legal advice. As a counselor, sometimes I'll tell you, from a practical perspective, I don't think that's really what you want to do. And we'll discuss the legal option and then the practical reality and consequences of exercising the legal option.
And the cost.
Right. As a matter of fact, I'll give the greatest example I can give my late father. It's always nice to have a child that is now an attorney. And my father used that to his best advantage. And I would often get phone calls. Stuart, this happened. I want you to write a letter. Well, usually the response was, yes, Dad. I'll do that, Dad. And, very often he was right and we got whatever relief. Sometimes they ignored us. But then there were times where I would have to say to him, Dad, you're right, but why fight this? I mean, nothing's going to be accomplished. I'll give a very, very, very brief example. My father was a salesman in the textile industry all his life. And he was a dang good salesman, I'll tell you. He could sell almost anything to anybody. And his problem in textiles was, when he was with big companies, he would go to, let's say, the Macy's or the old days Gimbel's. He had an office in the Empire State Building for a while. And he would sell them a certain amount of yards of fabric that they were then going to turn into shirts or sweaters or what have you. And then he'd get a call. That order that he had just presented exceeded the factory capacity alone. Forget all the other salespeople in the company. So we'd have to go back to Gimbel's or Macy's and say, we can't satisfy that order, which meant they were never going to order from him again. Okay, so no, you lose the commission, everything else like that. So, a couple times with smaller companies, he wanted me to fight over certain things, commissions and all. And I'd say to him, I can do it. I will do it. Sometimes I did do it. But whether you win or you lose, your future at this place is, you don't want to stay there. Find another place and move on. And then, you want me to fight for this $600? I'll write one of my letters. But if you don't want, as the word my father used, if you don't want the agita, then don't have me do anything. Just put it behind you and move on. And that is what I really tell a lot of clients. It's, here's the legal implications. Here are your legal rights. Here's the prospect for success that I see roughly. And here's practical reality. Here's what it's going to cost. A lot of times people will come in, I will fight on principle. And they mean it. They're not just spouting. They mean it. Until they find out how much principle costs. And then some of them still mean it.
Because you don't fight on principle. It's your job. You need to get paid. Yeah, you need to get paid.
Right, exactly. Unless it's a contingency case and I'm taking the risk along with them, which means that I'm accepting a certain degree of risk because I think the case has a certain level of value. And if I'm wrong, I don't get paid, or like in one case, I get paid 35 cents an hour effectively, which is really a loss.
That is on principle, isn't
in another case, this is why attorneys take contingency fee cases. In another case, effectively, my hourly rate was $3,000. You look for those cases to compensate you for the contingency cases where
you get 35 cents.
Yeah, and of course, usually it's not the client complaining about the $3,000 an hour, because if you're getting $3,000 an hour, they're getting a good chunk too. Okay? Usually they're not the ones complaining. Usually it's somebody, if it's a big public case or something, it's somebody on the outside in the public saying, oh, he got $3,000 an hour. That's outrageous. But what they don't understand is how a contingency fee law firm operates. And if it's not really hurting the client, then what's the problem? Because it's compensating me for all the other people I try to help, but I can't quite even get my hourly rate. So, I'm behind the 8 ball. And I will be honest, it doesn't happen maybe once a year, if that much, where I will get a contingency settlement where the effective hourly rate for the time I've put in is beautiful. And I don't feel bad about it, I'll be honest. I feel great about it because it was a big victory for the client, it was a big victory for me, and it helps the bottom line for the year. So somebody on the outside looks at it and screams and jumps up and down, but they don't understand the facts. And very often that's what happens when the public hears stuff and they
that's
come to their own interpretation.
Even like a realtor too. I mean, you work and you work and you work and you finally you sell that house. Maybe you sell a couple. Sometimes you have to share that commission, but in the big picture is at the end of the year.
Right. Now, great example there too. I mean, we're going a little bit off field, but that's okay. When I bought my house 2 years ago, we had a wonderful realtor, truly a wonderful realtor. And the problem was she had to have shown us 50 houses because very picky.
Mm-hmm.
Okay, this one, everything's wonderful, but the master bedroom is too small. This one, the master bedroom is gorgeous, and the bath, and walk behind the shower and everything, and it has 5 shower nozzles.
But power lines are going through the yard.
but the family room is tiny.
Okay.
Or the kitchen is tiny. Or it's, a $300,000 house, and instead of marble, it's marble laminate. I'm not buying marble laminate at that price.
Right.
So we saw a lot of nice houses, but for one reason or this is Chinese drywall. But it's been fully rehabilitated.
Goodbye.
I'm sorry, I'm not taking that chance.
Yeah.
I have a client that had a Chinese drywall problem.
Ooh.
So she had to work her tail off. Never a grimace. Never you're really putting me through my paces.
Mm-hmm.
It was always with a smile. It was always helpful. It was always let's see what we can do on Saturday or Sunday. Let's go 3-4 houses. And when she finally, sold my house, and then was the agent that I purchased my new house through, all right, she deserved her commission. Now, whatever she got out of it, because she's part of a company, was it worth it to her to have spent all that time with us? I don't know. But maybe when she sold the $5 million house, when the people saw only the third house they saw,
right.
Then she made a killing. And I don't think she feels bad about it. I don't think she should feel bad about it. And maybe it makes up for all the paces I put her through.
Mm-hmm.
And that's the way it is in business.
Yeah.
So my take on it. Bulldog, I think I still have you here. No? You gone?
I guess he's gone.
All right. Figured at some point Bulldog would have to drop away. Okay, thank you, Bulldog. So again, it's amazing how when you speak and the show almost disappears on you. We sort of started out by, this gentleman who came in yesterday and, being careful as to the opinion you get from your attorney, and the attorney being careful to really make sure that the opinion you're giving somebody is as likely to be correct as possible.
Well, if that client hadn't said that one more thing, but that was no one's wouldn't have been anyone's fault. That it would have been missed.
Honestly, if I had found out about it later, if somehow he had gone to another attorney, and I just happened to hear about the case, and I realized what it was that I had missed, even though it wasn't the client's fault, it wasn't my fault, frankly, I would have felt like it was my fault. If they're presenting documents for me to interpret and to give them an opinion, it's my job to interpret them correctly. Just because I make a mistake that doesn't constitute malpractice doesn't mean it's not a mistake. It doesn't mean it may not cost a client or a prospective client. Doesn't mean it may not cost me for losing a prospective client. So, it's my job during a consultation to try to get all the information I truly believe I need and understand where it is the client is coming from and what their goals are and what their needs are so that I can address them near the end of the consult when I have reviewed everything and understood as much as I can understand, and now I'm trying to give them an analysis. Just like not every mistake a doctor makes, not everyone is malpractice. Mistakes happen. Mistakes in judgment, mistakes in action, failure to diagnose. Failure to diagnose could be professional malpractice. But not all failure to diagnose is malpractice. So, just because it may not rise to a level doesn't change, in my view, the obligation of the attorney to do the very best job you can do when you're meeting with a potential client who has a serious issue. And it's not just about whether they're going to hire you or not. It's about whether when they leave, they're even thinking of continuing to pursue the matter or dropping it. I mean, you may have that amount of influence over them. And, I don't want to be wrong. It's the same reason I don't want to lose a case at trial. It's not just...
But realistically, that from time to time is going to happen.
I don't know any...
You may not like it.
I don't know any even extraordinary litigator. You look at the best litigators historically in the country, or even right now. I don't know a single one of them that will tell you they've won every case. It doesn't happen. But, if you're a litigator, not only are you an advocate for your client and you want to win for your client, when you get into the heat of competition, you're now a participant too. And your self-image and your ego is also rolled into it. Just like I don't want to lose a hearing, I really don't want to lose a trial. If I'm on a contingency fee, I really don't want to lose a trial because I'm not going to get paid.
Right.
If I'm on an hourly fee, it may not make a difference to me financially if I lose a trial. But you want to know something? When the attorney at the other table gives me that smirk before they leave the courtroom, after the jury returns a verdict against me, that smirk, I don't ever want to see it.
You want to be the guy giving it.
I necessarily don't want to be the guy giving it, but I don't want to be one of those attorneys where I'm going to be on the receiving end of the smirk. That's why they do it. It'll eat away at you. Okay?
Is it? So it's a deliberate smirk. It's just not
sure.
like automatic because you
not
kind
all
of feel
not all
like
attorneys
that.
do it. Not all attorneys do it. Some attorneys shake hands. They're very pleasant.
Eyes on the table. Put your papers away.
Yeah, but there are attorneys that will try to rub it in, just like there are athletes who try to rub it in. And look,
It's that competitive nature.
I'm a competitor. I'm a combatant. However you want to call it. Sometimes they say attorneys in court are gladiators, so I'm truly a combatant. I don't want to lose. And it comes down to I don't want to lose for the client. I don't want to lose for myself. It's a lot more fun, not only to win, but it's more fun when you are debriefing yourself as to what went wrong or right in a trial and why did a jury find one way or the other. To be debriefing yourself on a victory and looking at what could you have improved on the next time, than it is debriefing yourself over a loss, which usually comes on a Friday afternoon.
Ruins your whole weekend.
And now you have the entire weekend to ruminate over it. Look, some attorneys are able to just put it aside, honestly. And I'm not saying they're wrong, those attorneys that can do it. Okay? Maybe they got something on me for being able to compartmentalize like that. I can't do it. Okay? If I lose on a Friday afternoon, my weekend is ruined because I'm going to be going through what happened, what didn't happen. Was it something I did? Was it the way my client testified? Was it a witness? Was it evidence that the judge did or did not permit to get into evidence? Is there an appeal? Is it worth taking an appeal? All that stuff will be swimming around my head, and I guarantee you that Friday night and Saturday night I'll be taking one of my low-level sleeping pills because I'll never get to sleep without it. And if you ask any athlete, almost any athlete, or any big-time coach, they will tell you that the high from a victory is not as high as the low from a loss. Athletes want to win less than they don't want to lose. Not wanting to lose is more of an incentive than wanting to win. It's a psychological mechanism of how human beings are made up. And so, I want to win, but dang it, I don't want to lose. And so, that could be a whole nother show in terms of why that's important and what you do to try to achieve that and how you try to pick the cases you pick. If somebody's coming in on a contingency basis, I'm truly trying to analyze that case as best as I can with the facts I have and trying to extrapolate as to what I might be hearing down the road so that I don't take a loser. if I'm being paid hourly and I say to a client, in my opinion, you have absolutely no case. Well, I'm not going to take the case because I'm going to hit with a claim for frivolous action, and I may have to pay attorney's fees out of my own pocket. But, law isn't often black and white. It's mostly gray. So a client could come to me and say, well, how do you weigh my prospects for success? Well, clients actually don't ask it that way. They say, will I win or will I lose? Mm-hmm. And I say, like a doctor, I can't guarantee success. A surgeon. I can tell you that based upon what I know right now, haven't done any discovery, haven't heard of whether there's anything you didn't realize you should have told me that you haven't told me. But as what I have right now, attorneys generally look at it out of 10 juries, because they'll be different. How many times do I think I would win out of 10? And if you're going to accept any case, you want it to be as high as possible. Contingency case, you really want it to be 7 or 8 or 9 out of 10. An hourly case, if I say to a client, well, I think it's 50-50, and they say, I want to pay you to do it, I'll take the money. Mm-hmm. I'll do the dang best I can. And if it comes out on the other side of the 50, then maybe I saw it in the beginning as a good possibility, and there was nothing I could have done to prevent it. I did everything I could for the client. Hopefully at the end the client feels the same way, even though they're not happy with all the money they paid. And you'd be amazed at how many clients do feel okay about it.
But if you have a slim chance,
then I will tell a client that it's not frivolous, but I don't know, I think maybe you have 2 or 3 out of 10.
And you might be wasting your money.
Yeah, and if the client says, I want you to do it, on an hourly case, I will accept that client. I've been honest with the person. They understand the terms under which they're paying me. They understand they could change their mind at any time, and we'll get out of it. And I'll take that case. It's part of why people say lawyers are mouthpieces. Well, if you're going to pay me, I'll be your mouthpiece. Unless I absolutely believe you don't have a legal claim, in which case I think it's unethical to take that case. Mm-hmm. Okay? There's some attorneys that will. I think it's unethical. And I think the bar thinks it's unethical, too. So as we wind down another episode of Ask a Lawyer, which one day will be serialized and turned into a book. No, I'm just kidding.
You can start right now.
I'm not that good. I'm not that good. Haven't even picked up by like a West Palm Beach station yet. I'm so insulted.
Not that they're a better market.
But to the station manager who has the office right next door here, I'm so happy to be here. And you're so happy that I've chosen to be here. All right, folks. I hope you all have a wonderful weekend. We'll talk to you next Friday again on Ask a Lawyer. Coming up behind me is Ask a Rabbi. And by the way, that doesn't mean just ask a rabbi about Jewish stuff. This rabbi teaches world religion, comparative religion. Ask a rabbi, call her about anything. So my office number is 781-8003, area code 772. My name is Stuart Address, and yes, that's right, I know your address. So have a good day, and I'll talk to you next week.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.